a shoe design be a trademark? In this case, we are going to see an interesting legal battle where a footwear company, which is the most popular one called Crocs, filing a trademark to register the design of their sole. Now, the Registrar of Trademark does not accept this because they state that a design cannot be registered under a trademark because a design is a functional element of a product and it can be applicable only in design patent. It is not a brand identifier and hence it cannot be registered under trademark. This legal battle between Crocs Incorporation versus Registrar of Trademarks has some interesting facts to be known. Let's discuss this in this video. Myself Rohini, your intellectual property lawyer. Now we all know Crocs is a well-known footwear brand all over the world. They wanted to register a trademark for their unique shoe sole design. Crocs has a distinctive shoe sole design which they wanted to secure a trademark. So initially they applied for a trademark of their shoe sole design. Now the Registrar of Trademarks, once they verified this application, they stated that they can't give the registration for the design of this particular sole because it is not coming under the purview of a trademark. We all have seen in our many previous videos that trademark is a protection of your name, your logo, your brand identity and any other elements which is going to identify your product or services. In this particular case, it was the products and the design which they wanted to register under trademark. Now the key question which came before the court was whether the design of a product can be trademarked. Since the trademark registry refused to allow this trademark because it's a design of a product and it comes under the functional element of the product and not the brand identifier. Now what the Crocs did is they made an intelligent move to file a case against the Registrar of Trademarks claiming that this design they wanted to secure a protection under trademark.
Whoa! That's interesting!
Now the court ruled in the favor of Crocs. How? Think about it, when you see a sole pattern of a shoe which has a unique design and you can immediately identify that it belongs to the brand Crocs. This is because it is not about the product design or not just the aesthetics because to a customer it becomes a brand identity. The same I can give you an example like if you see a bottle of a Pepsi and a bottle of a Coca-Cola without its label, you will be able to find out and tell which one is a Coca-Cola bottle, which one is a Pepsi bottle. Because more than the brand, you have identified the bottles based on their shape. In the same way, if you take the sole pattern of a shoe, if you see them, the Crocs has a certain pattern and if you are a regular user of this Crocs brand, you will be able to tell that this brand belongs to Crocs. So from the consumer point of view, the design has become a brand identifier. Considering these points, the court has ruled the judgment in favor of Crocs and they also reinforced two important principles of intellectual property law. A design that makes the product identifiable by a customer, then it can be registered or protected under trademark. Number 2, a trademark is not just about registering your logo, label or brand name, but it also protects the shape and the design if the design qualifies to be a brand identifier. Why this case is important? This case actually brings a significant results to the business owners and the designers who can legally protect their product designs under trademark as well so that any other competitors may not copy and use another label. Let's take for instance another shoe brand tries to copy the design of the Crocs and they use a different design on the outer side but the sole of the shoe seems to be in the pattern of the Crocs and they try to use a different label. If they are going to market that product, a consumer will get confused whether it is the original Crocs brand or it's a duplicate one. In order to avoid the confusion of the customer, it is important for the owner to protect his product and the name both under a trademark and designs. But in this case, if your design becomes a brand identifier, then in that case you can protect it under trademark as well. This ruling will also inspire many other companies to protect their product design under the trademark as well. For example, if you are a car manufacturer, then you can register your unique car grills under a trademark. If you are a tech brand, then you can register your unique phone design also under a trademark. Fashion brands can also register their unique designs of the handbags to secure those designs from being copied. This case has proven that design is not just about the product, it's about protecting the brand identification from the customer's point of view. If you have a product and you have a question whether I can apply for a trademark, then call to this number and get us your queries clarified. Also, if you have any other doubts regarding a trademark and the design patent, comment below, we will answer you. More useful videos are upcoming in our channel, so kindly subscribe to our channel. Myself Rohini, your intellectual property lawyer.